Good afternoon. Thanks very much for joining Deeth Williams Wall today. We have an excellent presentation prepared for you. Today we have a program called Indigenous Culture versus IP Rights, Ever or Never the Twain Shall Meet. Our speakers today are Gary Daniel, who's counsel at Deeth Williams Wall, and Justice Fuhrer. Justice Fuhrer, I'm going to give a little bit of a biography on you because you don't get to appear before us every day, although you do appear before your own audiences. Justice Fuhrer was born in Toronto and raised in Bolton, Ontario. She studied law at Queen's University and was called to the bar in 1987. Justice Fuhrer spent several years working with Readout and Maybe. She's a certified specialist by the Law Society of Ontario in intellectual property law. She's past president of both the Canadian Bar Association and the Intellectual Property Institute of Canada. Justice Fuhrer taught trademarks and unfair competition law at Queen's University and served as Dean's Counsel. She's a previous associate editor of the Canadian Patent Reporter and former chair of the Trademark Agents Examination Board. Thank you very much for joining us today, Justice Fuhrer. And Gary Daniel. Gary, I'll pass it off to you.
Thank you very much, Jennifer, and good afternoon to everyone. We're delighted that everyone was able to join us today. So we are going to be talking today about Indigenous rights and how they relate to intellectual property. It is traditional to start with an acknowledgement and a land acknowledgement, and many of you in Ontario will have heard this before. I'm going to do a quick land acknowledgement based on the fact that we are here in Toronto, even though I know Justice Fuhrer is in Ottawa and others registered may not be in the Toronto area. But the land acknowledgement is traditional. We acknowledge that the land we are meeting on is the traditional territory of the many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat people, and is now home to many diverse First Nations, Inuit, and Métis people. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Next slide, please. What we are going to talk about today, we're going to hit on 7 or 8 topics. First, we're going to talk about the different sources of law that impact on both Indigenous rights and intellectual property rights. Secondly, we're going to talk about recent treatment of Indigenous rights. Thirdly, how Indigenous rights intersect with IP law. We're going to have an introduction to traditional knowledge, which is sometimes abbreviated as TK. We're going to spend a fair amount of time talking about the sort of paradigm conflict between the IP regime that we know in Canada with our current legal regime and traditional knowledge. We're going to talk about the difficulty of protecting traditional knowledge, but also options for its protection. I will speak for approximately the first half of the session and then turn it over to Justice Fuhrer. Next slide, please. So in terms of sources of law, we all know that in traditional Canadian jurisprudence, next slide, please, our sources of law are the ones that will be familiar to all us lawyers. They're legislation, which is passed by Parliament, jurisprudence, so judges interpreting the legislation as passed by Parliament, and to some extent, unwritten sources of law. And we'll touch base with that later, but I'd ask people to keep that one in mind. One of the significant paradigm differences between our law as we know it, for those of us who are lawyers, and brought up in the Canadian system, and Indigenous law, is that Indigenous law has different sources of inspiration. These include such concepts as sacred law, natural law, deliberative law, positivistic law, and customary law. Next slide, please. Just touching on them briefly. Natural law are laws that are being so-called written on the earth through nature and wildlife, and through land and climate and weather. I mean, think of the fact that, for example, we all know or believe that the sun rises in the east. That's not something that Parliament told us, but something that we know. When the seasons change, when the first snow comes in the regions in which we live, tend to follow certain patterns. Then there's sacred law. Now, sacred laws are regarded as sacred if they stem from the Creator. And creation stories in Indigenous legal traditions are also a source of law. And perhaps the best analogy I can think of is those people who follow religious beliefs. Whatever religion a person may subscribe to will have sacred texts and laws that come down from the Creator that religion chooses to believe in. So again, not that different a concept for many non-Indigenous lawyers. Thirdly, there's deliberative law. And this is a legal tradition formed through the process of persuasion, deliberation, counsel, and discussion. Now, we'll talk about this a little bit more, but it is interesting that here we have a legal tradition formed through discussion. And I think the best analogy that I can come up with in the non-Indigenous realm is the town meeting, or at least the way the town hall meeting is sometimes shown on television and in movies, of the citizens of a small town getting together to hash out the issues and decide on how they should proceed. Again, it's a little bit different than what we have with our legislatures and Parliament, but an important source of law. Next slide, please. There's also what's known as positivistic law, which is political in nature. And these are proclamations made by a group regarded by a sufficient number of people in the community as authoritative, typically the elders. Again, it's a little bit different than the concept of laws being promulgated by the representatives we have elected to the legislature or the Parliament. These are the senior and respected members of a community who give the law. And an analogy may be appropriate here would be the respect that would be given to senior members of a profession, senior members of a firm. It's not a question of necessarily outvoting, but saying, look, you've been in this business for many, many years. What do you think? We respect your opinion. The last one is customary law. And these are practices developed through repetitive patterns of social interaction, but importantly, that are accepted as binding on those who participate in them. And again, we'll pick up on this theme a little bit later in the presentation, but it is important to note that the notion of custom can itself form a basis of law. So now we've touched on the different places from which Indigenous law may come and how it differs from the way that laws are promulgated in our society. Now I'd like to turn on to recent treatment of Indigenous rights. Next slide, please. I think to start a discussion of the recent treatment of Indigenous rights, next slide, please, we have to speak about the Constitution. Canada, of course, has had a written Constitution for almost 40 years, and beyond that, but certainly the current version of it goes back to 1982. And we have Section 35, sub 1, which stated, quote, "The existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed." So it is crystal clear that the rights of Aboriginal peoples are a constitutional right, and it has been enshrined in our Constitution. Next slide, please. Canada is also a signatory to numerous international treaties, including the UN Declaration on the Rights of Indigenous People, sometimes referred to as UNDRIP. And as you see here on the slide, the General Assembly has taken note of the recommendations of a Human Rights Council contained in its earlier resolutions, and has adopted the UN Declaration on the Rights of Indigenous People as contained in the annex to the next resolution. Next slide, please. Whoops, next slide, please. Going forward, the UNDRIP does provide, page 11, please. The UNDRIP does provide that in Article 1, Indigenous peoples have the right to the full enjoyment as a collective or as individuals of all human rights and fundamental freedoms. Article 31 specifies that Indigenous peoples have the right to maintain, control, protect, and develop their cultural heritage, traditional knowledge, so here we have a specific reference to TK, and traditional cultural expression, also sometimes referred to as TCE. And they also have the right to control, protect, and develop their intellectual property, over such cultural heritage, traditional knowledge, and traditional expressions. So we see that the UNDRIP already deals specifically with intellectual property. Article 11 condemns past actions where these rights were taken without Indigenous peoples' informed consent or in violation of their laws, traditions, and customs. So again, it's not a question of it whether it's in violation of Canadian statutory law. The question is it in violation of their laws, traditions, and customs? Article 24 asserts that Indigenous peoples have the right to their traditional medical knowledge. Now, the UNDRIP was endorsed by Canada in 2016. However, as we know, in Canada, the mere adoption of a treaty, or in this case, a UN declaration, doesn't in and of itself affect domestic law. So as a result, while Canada has signed on to the UNDRIP, the question is to what extent, if any, Canadian law has been changed to accord with Canada's treaty obligations. We're now going to move over to a more detailed discussion of Indigenous rights and IP law. Next slide, please. Next slide, please. Currently, there is no mention of Indigenous rights in any of the Patent Act, Copyright Act, Industrial Design Act, or Trademarks Act. And indeed, there's a lack of protection or recognition of Indigenous IP rights in Canada. As I mentioned before, the mere fact that Canada may have signed on to an international treaty recognizing these rights doesn't automatically incorporate them into Canadian legislation. And this raises the question of the need for dialogue with Indigenous peoples to figure out what is going to work for them. I'm now going to turn it over to Justice Fuhrer briefly to comment on the duty to consult, which, as I understand it, goes a little bit beyond the traditional things that Parliament does when they strike committees and interview Canadians and people make submissions as to what the law should be. Justice Fuhrer, can I turn it over to you just for a minute or two on the point of the duty to consult?
Yes, thank you very much, Mr. Daniel. Really, the duty to consult is more than just the act of consulting. It needs to incorporate understanding, at least for it to be meaningful, of First Nations concepts of property and legal orders. And that really is the starting point for a discussion or dialogue with Indigenous people about how best to protect traditional knowledge and traditional cultural expressions, at least outside Indigenous communities.
And from that, we see that the duty to consult really does go beyond, as I was saying before, the simple holding of committee hearings where people come up to Parliament for a day or two and make 20-minute submissions at a time. It does go beyond that. Next slide, please. But there is hope on the horizon. 2 springs ago, in the spring of 2018. The Minister of Innovation, Science and Economic Development, ISED, announced that Canada would have an IP strategy that specifically would include initiatives to make Canada's IP system more inclusive and reflective of the needs and interests of Indigenous peoples. The question, of course, is here we sit in the fall of 2020, and while the government has announced this intention to have specific initiatives to make Canada's IP system more inclusive and reflective of the needs and interests of Indigenous peoples, we do sort of raise the question: what change has come so far? And at least legislatively, it appears to be relatively modest.
Yeah, Mr. Daniel, if I could, I just want to add that my comments about the duty to consult were based not so much on, and there is a lot of case law on this issue, what exactly the duty to consult encompasses, but more on having participated when I was still in private practice in some consultations with First Nations or Indigenous communities around Canada's IP strategy and this particular initiative. And just in dialogue with First Nations communities and listening to their concerns, it became abundantly clear that the Western industrialized systems of intellectual property protection in Canada may need to be reconsidered or may not be flexible enough to accommodate sufficient protection for traditional knowledge and traditional cultural expressions.
And this goes a little bit to the point we were talking about earlier about the paradigm difference, right? I mean, we have, you know, at its base, Canadian intellectual property law, and in fact, intellectual property law in all countries that I'm familiar with, is ultimately based on, you know, a certain notion of, you know, which monopolies are to be rewarded and which monopolies aren't. And even the notion of a proper monopoly, a government-sanctioned monopoly, may be anathema in some cases.
Yes, and we will get to that a little more in today's presentation.
So let's turn now to a discussion of why we should protect Indigenous cultural expression. Next slide, please. The question as to why we should protect Indigenous cultural expression plays itself out in many different ways. I mean, the most obvious one that I think most of us see is to prevent what can be described as cultural appropriation, taking advantage of someone else's culture for one's own financial gain or personal benefit when one is not a member of that community. A new word that has popped up in this is what's also known as biopiracy, and I'll go into a little bit more detail on that in a moment. But it's basically taking advantage of traditional knowledge as it relates to flora and fauna and other biological things for commercial gain. And we'll get to a couple of examples in a moment. As we talked about before, the international treaties, including UNDRIP, recognize the rights of Indigenous people in protecting their traditional cultural expressions. Another reason to protect Indigenous cultural expression, frankly, is to show good faith. We've heard expressions like truth and reconciliation, and if we're looking to have reconciliation with our Indigenous people, one way to do that would to try to prevent some of the negative things that happened in the past by showing respect for those cultural expressions that have survived over the years. We talked before about the UN Declaration Preamble. I now want to talk about some specific areas of IP law where the rights of Indigenous people come up. Next slide, please. The first one is trade secrets. Many Indigenous traditions and cultural expressions have been kept secret from non-Indigenous peoples, things like ceremonies, certain art, certain stories in terms of the oral tradition, and herbal remedies and medicines. Now, there's some good news here, perhaps, in that the common law of trade secrets, as we know it, does protect trade secrets, but as we all know, only so long as those secrets are kept secret. What happens when someone wants to have some limited ability to make something that would otherwise be secret public? The way our law is right now, it completely disappears absent, for example, a licensing regime. And the question would become, are you going to start to impose a licensing regime where people are going to have to document, well, this was a trade secret, but I let certain people know it and they're kind of inside the bubble, as it were, that they're contractually obligated to keep it secret. That's kind of our paradigm. I'm not sure that necessarily works, but at least in terms of trade secrets, there might be some ability of our current common law to accommodate some of it, but I don't know that it goes all the way. The next area of law will be patent law. And I just wanted to talk about, next slide, please. Patent law, where there are numerous examples of where our patent law doesn't quite jibe with certain scenarios. You'll recall a couple minutes ago, I spoke about the notion of biopiracy. There have been numerous examples, and we listed several here. There have been numerous examples where flora and fauna, and particularly flora, have been used as part of traditional medicine. So you have situations where Indigenous peoples for years, for generations, and sometimes for centuries and millennia, have recognized the healing properties of certain plants. I'm going to speak about one, and Justice Fuhrer is going to speak about another. I'm going to speak about paclitaxel. Paclitaxel was an anti-cancer drug that was developed from the bark of the Pacific yew tree, and its healing properties were known to Indigenous peoples in British Columbia as well as Washington State. The pharmaceutical companies ultimately came across the healing properties of the anti-cancer drug and came up with a product known as Taxol or paclitaxel that was used primarily to treat breast cancer. And so we have to ask ourselves the question of patent law, where we have the concepts of the inability to get a patent where something is in a printed publication, let's say more than a year before a filing date. Well, how do we deal with a situation where the fact that paclitaxel had healing properties and perhaps even anti-cancer properties has been known for hundreds of years, but of course there's no printed publication because hundreds of years ago nobody wrote it down? So it raises the question as to whether the pharmaceutical company was really the first person to discover it, whether they were the first person to invent, and what mechanism do we have if a indigenous it was known in the indigenous communities hundreds of years before the filing of the patent application. And Justice Fuhrer, I'm going to turn it over to you. You had some comments on the Hoodia plant.
Yes, that's correct. I think it might be a slight typo. It's the San, S-A-N people in the Kalahari Desert. They occupy a range of countries, more in the southern half of the continent, Angola, Namibia, South Africa, and Botswana. They are known to undertake long treks through the desert, and the stem of the Hoodia plant would help suppress hunger and thirst and boost energy on these treks. The South African Council for Scientific and Industrial Research was able to either extract or replicate a compound known as P57, which it had hoped to commercialize as an appetite suppressant. It obtained a patent, it licensed the patent, all without consultation with the San peoples. And it was interesting in reading a little bit about this episode that that phytofarm that was the licensee didn't consult or think to consult with the San people because they didn't know they still existed. But in any event, the San people got wind of this patent and challenged it, and eventually a benefit sharing agreement was entered into in terms of the commercialization of the patent, so that they received some financial compensation, for which they had plans for their various programs and undertakings. But it is an example of how consultation can assist in providing benefit to the Indigenous community that was the origin of the patent in this case.
And so it's a bit of a good news story there, but I think one of the things we want to ask our participants, our registrants to think about is, in these situations, whether it's Hoodia, whether it's the bark of the yew tree, where should our law go? Should we be making exceptions to our existing patent law to deal with, again, printed publications as prior art, or do we need a clean sheet of paper to deal with the situation where, like with Hoodia, like with paclitaxel, to deal with the situation where the traditional knowledge was used by someone in a commercial enterprise and get that government-protected monopoly? no answer to that question, but I think that's an interesting point for discussion. Beyond patent law, of course, we have the other substantive areas of IP law. And turning next to copyright law, next slide, please. Copyright law, again, raises its own issues. As most of us know, Canadian law for many, many years has started the discussion of copyright with the notion of authorship and fixation. So our Copyright Act is based on the fact that one or more authors create a work in which copyright subsists, and two, that the work in which copyright subsists has to be fixed in some tangible form. Many of us are familiar with the adage that copyright doesn't protect ideas; it protects the tangible expression of those ideas. Again, that works well in a situation where everybody is reducing things to writing or reducing them to video. But as we've seen, if we have an oral tradition, we have a problem with the fixation requirement. We also potentially have an issue with the authorship requirement. What happens when the author is unknown, or the author was someone who could be identified but was from generations ago? This raises the next issue, of course, which is the finite term of copyright. As most of us know, copyright stems from the life of the author plus 50 years. It may be extended to 70 years. But at the end of whatever period of time that totals, the copyright expires and the work is in the public domain. Again, that may be an appropriate scenario for certain commercial works, but we have to ask ourselves the question, does that paradigm fit with a work that is traditional, where the author might not be known, where it hasn't been reduced to writing, but even if there is an author and there is fixation, it is something that is intended to be protected for an indefinite period of time. One concept that we do have in our law that I think could be argued in the right fact pattern by skilled counsel is the question of moral rights. As those of us who practice in the area of copyright know, moral rights don't really have anything to do with morality as we know it. It's sort of a poor translation from the French droit moral, in other words, personal rights. Copyright is an economic right. So if I paint a picture, I'll be the author of that picture and I will own copyright in that picture. I can sell the picture to someone else and keep copyright, or I can sell the copyright to someone else, and that happens quite frequently. But if I sell you the copyright in the painting that I made, the one thing I can't sell to you is my moral rights, the fact that I painted the picture. It's what's known as an inalienable right. It's not a right that can be sold. We also know that with moral rights, we have this concept in certain cases of the author of a work having the ability to restrain certain activities with the work, but only to the extent that it prejudices their honor and reputation. I point this out only to say that if we go the route of trying to use current law to work with the paradigm of Indigenous rights, moral rights may be a ground to argue that we already have a concept in our law that there are certain rights that are inalienable and certain rights can be violated if they are used in certain ways which are to the honor or prejudice of the author. The problem,
I was just going to add one more, and that's the collective rights. And it's a concept that comes up in the Neil Peruru case in Australia that's listed in the presentation, and we'll get to it in a little bit.
No, that's right. So we have some tools that if we need to, we either may be able to use or may allow Parliament to expand upon. So I just want to sort of leave the thought that some of these tools are already in our law. We have some work to do, but we already have some of those tools. Turning to trademarks, next slide, please. This is the one that'll probably be most familiar to many of the registrants. There have been many recent cases of trademarks that have been found to be offensive by the Indigenous community. The professional football team in Washington is probably best known for both the litigation and the fact that as recently as this year, it ultimately changed the name of the football team. The Cleveland Indians case is an interesting one because it was one that was argued in Canada. But the facts of it really weren't argued strictly on the trademark side. As many people know, the Cleveland, the professional baseball team, the Major League Baseball team in Cleveland has gone by the name of Indians and has had this mascot, this somewhat cartoonish representation of an Indigenous person as their mascot. The case in Ontario involved a human rights claim, and the argument basically went as follows. The Cleveland Indians were scheduled to play the Toronto Blue Jays a few years ago here at the Rogers Centre. And shortly before the game was going to be broadcast on television in Canada by Rogers, the plaintiffs brought an application for an interlocutory injunction to try and restrain the broadcast on the basis that the use of the team name, and in particular the use of the mascot logo, was offensive and would violate their human rights. The application was dismissed primarily on the basis of when it was brought. It was brought on the eve of the game, so it was really dismissed on the basis of balance of convenience. And so there really wasn't a full airing of the question as to whether or not the mascot itself was offensive or the team name was offensive from a trademark point of view. But the case is still instructive from a Canadian point of view, showing what sort of tools may and may not be available. Next slide, please. There has, however, been some progress that really hasn't involved specific legislation. The trademark on the left may be familiar to many of you if you're a CFL football fan. It's the Edmonton Eskimos, which is a professional football team in Edmonton. And they had originally, when the issue had been raised that the name of the team was offensive to many northern Indigenous communities, the team originally took the position that it had consulted widely with Indigenous peoples and northern Canadians, and their research showed that the term was not found to be offensive. Nonetheless, earlier this year, the team announced that it would be changing their name. It hasn't specifically identified what the name will be. It will be interesting to see whether they are going to keep the double E logo, which I don't think falls into the same category, or whether they go through a complete name change. The trademark on the right is also an interesting example. Land O'Lakes butter has been around, it says, since 1921, so almost for 100 years. The image on the top shows a representation of what appears to be a kneeling Indigenous woman, and for reasons that we don't really need to get into, that is seen to be quite offensive. Again, of their own initiative, they have gotten rid of that part of the trademark, but they have left the part of the trademark that is presumably not offensive. Right, the words Land O'Lakes, a representation of what looks to be a sort of a bucolic lakefront scene. And they've added the fact that it's farmer owned. So what we see is there are abilities to make changes that may offer trademark owners the ability to still sell their goods and services and keep their primary trademarks while getting rid of imagery that would be offensive to Indigenous Canadians. I should also point out that just this morning, sort of breaking news, I happened to log on and see that CBC was reporting that a senior men's hockey team in Morden, Manitoba, had whose name was the same as actually the former Washington football team, and whose logo was very similar to that of the Chicago Blackhawks professional hockey team, had announced this morning that they were changing their name to the Washington Bombers, the Morden Bombers, and were changing their logo to essentially a stylized letter B, which presumably will not be offensive to anyone. Next slide, please. In terms of trademark rights owned by Indigenous communities, there are some, our current law does give Indigenous communities the ability to protect some of their own rights. For example, one of the First Nations has registered 10 petroglyphs under the Trademarks Act as official marks. As well, as you see, the representation on the right are sweaters, and these are considered genuine Cowichan sweaters. And the Cowichan have registered genuine Cowichan sweaters as certification marks under our Trademarks Act. So again, this is an example of trying to work within the current paradigm. Next slide, please. Nonetheless, there have been situations that are more subtle in terms of trademarks that have caused concern. Here's a report from CBC recently where a non-Indigenous clothing designer caused concern, or in the case of this headline here, outrage among Indigenous designers in British Columbia over her claims that her company was partially Indigenous owned. There's some dispute over the facts of the case, but again, we can the point to be made here is even claims of connections to the Indigenous community, whether by ownership or otherwise, can raise issues and begging the question, do our laws having to do with, for example, passing off sufficiently allow a claim to be asserted in the current paradigm? Justice Fuhrer, you talked earlier about collective rights. We know that we have examples of collective rights in, for example, some of the wine cases where wine growers from a particular region or cheese makers from a particular region have been able to say, well, if you're not from our region, you can't use our name. Some of the liquor cases from the early 70s and 80s come to mind. The question becomes, to what extent are we going to be able to, does our law allow us the collective rights, which you were mentioning, to deal with situations like this? Next slide, please. Here's an example that I think we've seen in different forms over the past couple of years. The use of feathers in particular, for many Indigenous peoples, is considered one of great importance. And when used, here we have a model using it, pardon me, we have a model using it, just what appears to be in a fashion sense, and a model, certainly the models on the far left and far right do not appear to be Indigenous. The question then becomes, do we have tools that would allow a remedy to stop this? We talked briefly about geographical indications of origin. Could an Indigenous community that used the representation of the feathers as representing its particular tribe have a claim based on geographical indication of origin? I don't have an answer to the question, but I think it's a question worth raising. Another option that we have in our law that is, next slide, please, is somewhat of an unusual one, but it's what's known as the Stolen Valor Act, or Stolen Valor. So for those with a military background, they will know that our criminal code prevents people from dressing up as soldiers. Now, there may be a public safety reason for that, similar to the reason people should not dress up as law enforcement officers. But we have in our criminal code something very specific, and it's section 419B, and it says that every person is guilty of an offense who, without lawful authority, quote, wears a distinctive mark relating to wounds received or service performed in war, or a military medal, ribbon, badge, chevron, or any decoration or order that is awarded for war service or any imitation thereof, or any mask or device or thing that is likely to be mistaken for any such mark, medal, ribbon, badge, chevron, decoration, or order. So the reason I raise this one is to say that our law specifically makes it a criminal offense to dress up as certain members of, in this case, the Canadian military. But it doesn't specifically say the Canadian military, and an argument perhaps could be made that something like an eagle feather could fall within this definition. I'm not sure that a Crown would necessarily want to prosecute. I don't know that a prosecution, depending on the facts, would be successful. But again, what I am suggesting is that we already have in our criminal code concepts that do prohibit the wearing of certain types of regalia. And even though many might look at this in terms of traditional military, the Royal Canadian Air Force and so forth, there is a question as to whether either this statute could be used or whether it could form the basis for broadening that might protect Indigenous expressions. Our Trademarks Act, of course, also talks about prohibited marks in Section 9. And in Section 9(1) sub D, it says no person shall adopt in connection with a business as a trademark or otherwise, so it doesn't have to be in terms of trade, any mark consisting of or so nearly resembling as to likely to be mistaken for D, any word or symbol likely to lead to the belief that the goods or services in association with which it is used have received or are produced, sold, or performed under royal, vice-regal, or governmental patronage, approval, or authority. Now, again, a traditional reading of that would suggest that when we're talking about regal and vice-regal, we're talking about Her Majesty the Queen and the Governor General. And when we're talking about governmental, we're talking about the federal government, provincial government, perhaps municipal governments. But again, an argument could be made that if the government is a First Nation, why would that not necessarily apply? And what happens if it's not even a formal First Nation, but tribal elders? If the wearing of certain regalia would lead to the belief that there was some association with them, could Section 9(1)D be used? Again, I don't know, but the point is we have these concepts already in our law. We also have Section 9 sub 1 sub J, which prevents the adoption of any scandalous, obscene, or immoral word or device. We talked earlier about the Washington Redskins case. I mean, in a somewhat analogous section in the United States, that's how this was argued, that the use of a trademark that was offensive to a certain subset of the population would be scandalous, obscene, or immoral. But I'm not sure that that's the way that these cases are likely to be argued in the future. But at least that tool is there if it wants to be used. And again, if the jurisprudence turns out that these terms are not found to be scandalous, obscene, or immoral, then the question becomes, do we have at least a basis to expand Section 9(1) if we want to prevent against some of these activities? Next slide, please. One of the considerations, however, that mitigates against it and is somewhat uniquely Canadian is the constitutional question. So number one, of course, and we see this more in the United States than I think we do in Canada, but the question, of course, any defendant who would be charged criminally would presumably assert in their defense their constitutional right to free speech, and whether the extent to which that may involve personal speech versus commercial speech. This body of law has been much more fleshed out in the United States than in Canada, but is something that I think we would have to consider, and in appropriate circumstances, and if we go the route of sui generis legislation to protect Indigenous IP, query whether some of the sections of it might would withstand constitutional scrutiny, or whether the legislation itself would have to use the notwithstanding clause. The other issue that's uniquely Canadian from a constitutional point of view is the difference between use and registration. Again, I could see an argument that while the federal government has jurisdiction over the registration of trademarks, the question of use of trademarks of common law is arguably a shared jurisdiction between the federal and provincial governments. And what happens if the federal government tries to legislate in order to protect Indigenous rights on how a trademark is used? Again, you get this interesting constitutional argument between its ability to legislate with respect to Indigenous rights, but its shared jurisdiction with the provinces as it relates to the common law use of trademarks. I'm going to turn it over to Justice Fuhrer for the second half of this presentation in a moment, but I did want to touch on the fact that Canada is not alone in this issue. Next slide, please. There are several examples of international countries outside of Canada that have dealt with the rights of Indigenous people as it relates to IP. The last bullet point, New Zealand, I would submit offers what was currently the current gold standard of legislated trademark protection for Indigenous peoples. I certainly don't have expertise in New Zealand law, but I've certainly spoken to enough counsel in New Zealand to know that their laws deal very specifically with the protection of Indigenous rights, and particularly the Maori people in New Zealand. Other countries like Australia and the United States have taken steps to protect the IP rights of Indigenous people. The U.S.'s take on it is that they prohibit the registration of marks that consist of, quote, matter which may disparage persons living or dead, institutions, belief, or national symbols, or bring them into contempt or disrepute. Again, an interesting question, whether our Section 9(1)(d) takes us that far. Is this language we could look to if we're looking to make some sort of incremental change? These will be interesting topics to cover. But at this point, I want to turn it over to Justice Fuhrer, who will now pick up the discussion and start talking about an introduction to traditional knowledge. Next slide, please.
Before I do that, or maybe as part of that, if you could go back to the last slide for a minute, please. The Milkaruru case is interesting. In that case, you had three, I believe it was three, but you had Aboriginal artists whose works were pirated, if you will, into carpets produced in Vietnam and then sold in Australia. And the court in that case was able to find copyright infringement, I think in part because you had artists who were still alive, but their works incorporated traditional artistic styles and themes. And where the court took that into account in terms of protecting their culture was in the damages, not so much in the infringement or the finding of liability, but certainly in the damages. So I found that an interesting approach to try to provide some protection for the Aboriginal peoples and their artistic works in Australia. All right. So next two slides. A difficulty encountered with traditional knowledge is that to some extent it defies definition. There really is no concise or generally accepted definition. It is understood to refer to or include knowledge, innovations, the practices of Indigenous and local communities, which have extended histories of interaction with the natural environment. It may be, or it may involve experience gained over centuries or decades at least, and adapted to local culture and the environment. It tends to be transmitted orally between generations, and it tends to be collectively owned. Even the concept of ownership is a difficult one. Custodianship may be a more accurate concept and takes the form of stories, songs, folklore, proverbs, and the like. Next slide, please. So the World Intellectual Property Organization, also known as the WIPO or WIPO, has attempted to formulate a definition of traditional knowledge, which is knowledge, know-how, skills, and practices that are developed, sustained, and passed on from generation to generation within a community, often forming part of its cultural or spiritual identity. And we saw some of those concepts in previous slides. Next slide, next. So, as we've mentioned or alluded to in the presentation so far, there certainly is a conflict or tension between Western industrial intellectual property concepts and traditional knowledge and traditional cultural expressions and how best to protect them. Next slide, please. For example, Western IP rights tend to promote innovation and creativity while also promoting or encouraging commercial use of new knowledge and inventions. There's the use of monopolies that are granted to creative individuals in exchange or in recognition of the knowledge that's developed. But this knowledge is developed in isolation and it doesn't become public until a more advanced stage in the process. Often the case, not always, but often the case. And it's because of the monopoly that the knowledge does become public, except, for example, in the case of trade secrets that we touched on earlier in the presentation. Traditional knowledge tends to be quite different. It's not necessarily commercialized, although we have seen instances where it has been to the benefit, though, of the larger community and not just an individual or a corporation, for example. The knowledge tends to be treated as a communal endeavor or effort developed through relationships between or among others and the land. Next slide, please. But there is value in protecting traditional knowledge. The Truth and Reconciliation, or TRC, Truth and Reconciliation Commission, or TRC, recognized the value of traditional knowledge. It was certainly an integral part of the report that was produced, and it was used as a guide in producing that report. The TRC emphasized the importance of oral history and TK for Indigenous law and identity, and protecting traditional knowledge or respecting it may be of assistance in the reconciliation process. So next slide, please. And the primary purpose of protecting TK is to provide its owners, we've got that in quotes, as I mentioned, custodians may be a better term, with some prospect of economic development and control of their knowledge and cultural identity. It can promote innovation through the dissemination of knowledge, provide an opportunity to learn from Indigenous groups who have sustainably used biological resources for generations, and provide economic value to Indigenous groups and developing nations. Next slide, please. Okay, some of the difficulties in protecting TK. Next slide, please. So we've already seen the issue of trying to define traditional knowledge. And it is difficult to provide protection for something that has an elusive nature to it. That is, it's not easily identified or specified. A more comprehensive definition, on the other hand, may make it harder to design an appropriate protection regime, in that it may not be flexible enough to accommodate changes in traditional knowledge. For example, I should point out that notwithstanding the use of the term traditional knowledge is not necessarily static. It can evolve with time. There can be new traditional knowledge created. So restricting TK to a particular area is problematic, as the slide points out, because it is changing. In terms of context, each Indigenous group tends to be associated with a particular territory and form of TK, but of course you have some that are nomadic as well. Another challenge is that there are many different Indigenous groups. So defining the concepts associated with TK risks abstracting it from the underlying context that give it meaning. Next slide, please. Then we turn to the issue of costs. Protecting levels, or the different protection levels and registration procedures for various types of intellectual property vary significantly across jurisdictions. That's true domestically and internationally. Notwithstanding efforts to harmonize over the years, it's often necessary to have professional advice for registration and commercialization, I'll add. And it may be necessary to apply in more than one jurisdiction. IP, in terms of privatizing traditional knowledge, again, that almost it seems like a contradictory or a difficult fit in terms of conceptualizing what that means, but IP protection could remove the social basis for generating and managing traditional knowledge, which is contrary to the communal nature of traditional knowledge. So it may impede, or could impede, future development. Next slide, please. So what options are there then for protecting traditional knowledge? Next slide, please. Well, it could be a license or some kind of benefit sharing agreement, as in the case of the San peoples and the Hoodia. It could be a practical means for Indigenous groups to define circulation routes and access obligations for digitally available traditional knowledge. But it could be in the end limited to material that is subject to copyright. But again, you can start to get a sense of how this is not an easy fit. It's almost like trying to shoehorn a large foot into a small shoe. Next slide, please. In terms of the patent world, there are some prior art databases that have been developed in different countries. In India, they have a traditional knowledge digital library. In China, a traditional Chinese medicine patent database for examiners. And South Korea has a Korean traditional knowledge portal. And these databases tend to be available to the patent examiners to search for prior art that could be cited against patent applications. Next slide, please. And we also have the possibility of private actors, such as libraries, museums, and archives that are used to controlling large amounts of information and cultural histories, and could be used to do likewise for Indigenous artifacts and works. They could work with Indigenous groups to ensure representations of TK are accessed in ways to preserve cultural value. That said, again, it's not an easy concept to visualize because it's almost like trying to put a little fence around something that may be a lot more fluid and a lot more accessible, absent being housed in something like a library or a museum or an archive. Next slide, please. The other possibility is a sui generis regime or system. And again, we touched on New Zealand, but they are present in other jurisdictions or countries, including India, the Philippines, and Peru. To be effective, it requires the incorporation of legal concepts from both IP and non-IP areas. And that's touching a little bit on what I mentioned about understanding legal, Indigenous legal concepts and traditions, the coordination of various levels of government, the balance of defensive and positive protection values. But again, that's already, you can see the creep of the westernized industrial IP concepts there. And again, it may need to be discarded for it to be truly effective, but at this point, it's really hard to visualize until people start to talk more about what this could look like. Next slide, please. There could be protocols developed used to control when and how traditional knowledge is used in regulatory hearings, for example. It could include prior informed consent to undertake a traditional knowledge project, some form of confidentiality provisions, especially where we're dealing with trade secrets, if they're involved in this type of project, recognition of, or better recognition of a non-derogation of the Section 35 rights under the Constitution Act, benefit sharing, again, as in the example of the San peoples and the Hoodia, or the recognition of community ownership over all generated knowledge. Next slide, please. So the WIPO Intergovernmental Committee on Intellectual Property and Genetic Resources, Traditional Knowledge, and Folklore has been long at this, more than 20 years, trying to negotiate terms, suggested terms, recommended terms of something that could be a treaty. But in any event, plans to finalize an agreement on an international legal instrument or instruments to ensure the balanced and effective protection of TK and traditional cultural expressions is ongoing, as far as I'm aware, but as I mentioned, has been for a long, long time. It's, you know, I've had the privilege of witnessing WIPO meetings over the years, and it really is a skill to arrive at a consensus among 100+ nations, jurisdictions, etc., on the various treaties that WIPO has, WIPO manages and has developed over the decades. And this is but one project that they have worked on in that regard. Next slide, please. All right, I think that's it. We want to acknowledge Juliet Saccharin, a former student at law at Deeth Williams Law, for her contribution to the presentation, which was partially derived from an internal presentation. I probably should have this to you, Mr. Daniel, but in any event, given by her on this topic in 2020.
Yeah. Justice Fuhrer, thank you very much for that. We're happy to open up the floor to questions by using the chat. But I think I just wanted to start it just to follow up on a discussion that Justice Fuhrer and I were having before the webinar started. I mean, as you will have seen from the presentations given today, there are lots of options for how Canada proceeds forward. And of course, they span a spectrum from, I guess, do nothing to make some changes. And if you're going to make some changes, how do you make them? Again, we gave some examples of using the law as it exists. And I guess, Justice Fuhrer, that would involve, if people wanted to bring claims, creative arguments by counsel in one form or another. I came up with some ideas. I'm sure other counsel can come up with others. The second would be amendments to the Patent Act, the Trademarks Act, the Industrial Design Act, the Copyright Act, along, plugging holes or making amendments to the existing legislation. And one would be sui generis legislation dealing specifically with Indigenous rights and possibly combined with perhaps the existing legislation that governs Indigenous peoples. Do you have any sense as to which way is more likely to happen, or which would work better? And again, I'm mindful of the fact that you're a sitting member of the bench, and so you have to be circumspect on what you say. But
well, it is very difficult to predict how this may unfold in terms of Canada progressing on an agenda to internalize, if you will, the United Nations Declaration on the Rights of Indigenous Peoples. And again, I mentioned that I have been privileged to participate, to listen to Indigenous peoples, First Nations peoples from across the country talk about the challenges of realizing the IP strategy and the components dealing with Indigenous IP when we're talking about trying to shoehorn it into existing laws. So where we go from there is difficult to say. I know there are a lot of conversations some conversations that are ongoing on this topic, and I think we'll just have to see how it unfolds. It's certainly not, when Canada endorsed UNDRIP, I listened in to the UN proceedings at that time, and it certainly was made clear that this is not an easy process, and it's not a quick one. It will take time.
I'm being told that we have a question from the, I'm not sure we say from the floor, but I will have to rely on my colleague Jennifer Davidson to bring it to our attention.
Thanks very much, Gary. So, Gary, I think this question is going to be more for you because I'm not sure Justice Fuhrer will be able to respond, but I'll leave that to her discretion. Have there been any moves on the part of Indigenous groups to seek statutory protection, either within existing statutory regimes or be developing new rights, perhaps in the same way as was done with the Integrated Circuit Topography Act?
Well, yeah, it's a good question. As I mentioned earlier in the presentation, some Indigenous groups have taken advantage of the current system. You'll recall one of the earlier slides was dealing with the genuine Cowichan sweaters, and that was taking advantage of the certification mark regime that already exists. That is available to both Indigenous and non-Indigenous people. We've also seen the registration of official marks, not really registration, but the advertisement of official marks for certain symbols of Indigenous people. So there has been some effort to use the current system, but as Justice Fuhrer points out, there is some element of, do we want to encourage or discourage sort of a shoehorning of Indigenous rights into the current paradigm? And actually, it raises sort of a second question, which is, do we, or I guess, does the government need to do a better job of educating the population, both Indigenous and non-Indigenous, as to what the issues are? And the answer is, I don't know the answer to that question. I'm not sure, Justice Fuhrer, if you have any thoughts in that regard, whether it's partly it's also an education question.
Oh, certainly there is an educative component. And I'm not sure I have any solutions or anything to add. Yeah.
So I think where we are is that, yes, Indigenous groups have taken advantage of the current system in terms of trademarks, certification marks, and official marks. And again, part of the answer may be found in the existing legislative regime as we have. But I think, as we've seen in this presentation, there are just some areas where my view would be certainly that is a bit of a square peg into a round hole. There are some areas that our current law, probably as drafted, just can't accommodate because the paradigm is so completely different. We gave the examples with copyright, for example, where if you have something that's not fixed, you're just not going to get, the way the law stands right now, you're never going to get copyright protection for it.
The one, anecdotally, the one example that occurred to me during our presentation, although it's not IP related, was the extension of copyright for Peter Pan. Now that was done through legislation, I understand, in the UK, so that the hospital that benefited from the royalties from Peter Pan could continue to do so. And so something like that may be possible, but yeah.
Though, as I'm sure our legislators will tell us, it's always more complicated than we as counsel or representatives of businesses think it is. Any change to any of the IP statutes might also run into issues with, NAFTA or CUSMA, trade agreements that Canada has with other countries. If we say, well, we're going to amend the Trademarks Act or the Copyright Act to deal with this one particular situation in Canada, that may raise issues with our trade partners. I'm not a trade lawyer, obviously, but we know that the changing legislation is not simple, and there are multiple considerations. But a journey of 1,000 miles begins with a single step, I assume.
Gary, thanks very much. I'm just going to jump in for a moment and introduce the audience to the Q&A function at the bottom of the screen. The chats have been disabled, but you can submit your question through the Q&A box, which you will find as the second icon from the left. I do have one other question for you. We've used Indigenous groups almost as an aggregate concept. Is there a possibility of conflict between different Indigenous groups? Is this a real issue?
I imagine it could be. I mean, they're as varied as there are nations, political nations around the world.
Well, I would say definitely, Megan. Without going too far afield, there are numerous examples, not in the Indigenous context, of people's different groups claiming, whether it's areas of land or things that they're considered, important to them or sacred, that one group says, "Oh, it's ours," and you can't use it. So I think that is a real concern. And as Justice Fuhrer, you pointed out, we use the term Indigenous sort of collectively, but there are a very large number of Indigenous communities, and just like society in general, there will certainly be disagreements over them, and of course that's why I guess courts were invented. But no, I think it's an excellent point. We have to be careful not to lump in all Indigenous communities and treat them as a singular monolithic entity with singular monolithic views. I think society as a whole, right, you always find a spectrum of views.
It's another challenge of consultation.
Right. I mean, yeah, because while there are structures, certain political structures in place with the Assembly of First Nations and so forth, just like, we all have governments that, we don't necessarily, agree with and have different viewpoints on, and disputes end up between different members of society. So I think it's an excellent question. I think, while again, I would argue that we have to start somewhere. There's almost no question that whatever regime was ultimately come up with, whether it's amending current legislation, whether it's having sui generis legislation, there's going to be disputes over them, whether among Indigenous communities or between Indigenous and non-Indigenous communities. And luckily, though, we have lawyers and we have judges. That's why we're all here, I guess. I see a notification on the Q&A, but I don't. Let me see if I can. Oh, there's a question from an anonymous attendee who says, "Can you let us know in general terms how New Zealand deals with this?" I can only answer at the highest level because, of course, it's a matter of New Zealand law. But I did say that New Zealand is generally regarded as the current gold standard of law as it relates to protecting its Indigenous IP. I know there are specific restrictions on the use of the term Maori, which in fact have been registered as trademarks, at least in some countries, for products. There was a case involving, I believe, cigarettes that were branded Maori in another country. I believe Israel, but I'm not entirely sure. And the New Zealand government was actually able to both pass domestic legislation and I assume exert some international pressure to get the name of the product changed, because it was considered particularly offensive to the Maori people. But in terms of the specifics, I can't go much beyond that. I'm not sure, Justice Fuhrer, if you know more than I.
Oh, maybe just a tad more. I believe there's, on the trademark side anyway, I believe there's a council or committee of Indigenous Maori elders or leaders with which the government consults when it has any questions about trademarks that could be offensive or in some other manner not acceptable. It's been a while since I've actually looked at the details of the New Zealand regime. Certainly it would be available if you visit the portal or the website for the New Zealand Intellectual Property Office or Trademarks Office. I'm sure you could get some details there.
Yeah, but an excellent question. I wish we had a more detailed answer for you. But that certainly can form at least a basis for further research and investigation. I think that might be it for, that looks like it's from questions from the floor.
That's correct. That concludes our questions, and I will pass it off to Richard.
Thank you very much, Jennifer. But thank you especially to Gary Daniel and Justice Fuhrer for a very, how do I put, a presentation that certainly opened my eyes. I have come at IP for many, many years from the perspective of a technology lawyer. What you have done is made me think about IP rights, not from the traditional technology perspective of incentives to innovation, but rather in terms of cultural rights, biopiracy, and other perspectives, which for me is a very new one. And so I come away from this with new perspectives and new knowledge, for which I'm very grateful. I also appreciated, Justice Fuhrer, your exploration and discussion about traditional knowledge, because it forces me to think about traditional methods protecting intellectual property and say, whoa, wait a second, I'm not sure these are completely appropriate to all of the challenges that we're going to be facing going ahead. So I come away from this with a new perspectives, greater insights, and I hope greater understanding. And I think in saying that, I am speaking for many people on behalf of the audience. Thank you very much to both of our presenters. It is a tradition at Deeth Williams Wall when we have a speaker from the outside, as Justice Fuhrer has kindly agreed to participate, is that we make a presentation or a gift to our speaker. Clearly, that is not something that is appropriate in these circumstances, but in recognition of Justice Fuhrer's contribution today, Deeth Williams Wall will be making a donation in her name to the Daily Bread Food Bank in Toronto. So we thank you, and I know that the Daily Bread Food Bank will thank you as well. So thank you to everyone. A final note, Deeth Williams Wall has had for the past several years a tradition of trying to present CPD sessions to our colleagues and friends. Our plans this year have been somewhat decimated by, like so many other things, COVID-19. It has run rampant over those. However, we're actively working on new presentations, including one focusing on good faith in the time to come. So please pay attention and watch for the announcements coming on that. With that, a final thank you to Gary Daniels, to Justice Fuhrer, and to everyone who has attended today. Thank you. Bye for now.
Thank you.
Thank you, Justice Fuhrer. Thank you, everyone, for attending. This concludes today's session. Thank you very much for your participation and your attendance. Thank you.